other debt, and, for example, who are living in negative equity. To what extent will the financial institutions engage in debt forgiveness and write-down? There is absolutely no doubt that we have thousands of individuals for whom debt forbearance under the concept of the personal solvency arrangement will not resolve the issue. It won't resolve it for the debtors, it won't resolve it for the financial institution. There is going to have to be a constructive engagement by the financial institutions in respect of individuals based on their individual circumstances to recognise that in some instances debt forgiveness or debt write-off is appropriate. Deputy Donnelly and myself have, for the sake of simplicity, regularly used the example of the homeowner who's borrowed €400,000 to acquire a home, whose home today is worth €200,000. They're in negative equity by €200,000. Their personal circumstances and income is depleted, and they can no longer make the mortgage repayments. And they have no other assets, no other assets. And they may, indeed, it may be a married couple who are trapped in an apartment with 2 children, home never constructed to accommodate 2 children. For individuals in those circumstances where there's no reasonable prospect in the medium term of their financial position changing, debt write-off is crucial. It's crucial for their personal circumstances. It's crucial in the context of enabling them to again participate in the economy of this state and contribute to domestic economic growth. So for pure selfish state reasons, the state has an interest in them exiting from debt. And from the financial institutions' perspective, it's important that where that is the position, that losses are actually crystallised and that there isn't an artificial value attached to the loan in the bank accounts. Now, financial institutions have been recapitalised to facilitate addressing this issue, not just in other areas, but in the mortgage debt area. And they've been stress tested. And the time has come for financial institutions to recognise that there is a need to deal with this in the manner that is appropriate based on the individual circumstances of someone who is in serious debt, and having regard to the level of that debt and under the context of the structure of the personal solvency arrangement. Now, I know, as deputies will be aware, I think it was about a week, 10 days ago, AIB made a very helpful comment about this issue, and they did make it clear that for individuals who are engaging with them, who are in serious debt of this nature, that there will be some of their customers for whom debt forgiveness is the only route to travel, and they recognise that. And that doesn't mean the writing off of all of the entire debt in its totality, but the writing off of a portion of the capital due to recognise reality based on current values and where an individual stands. Now, there's been certainly, we know, a small number of instances where financial institutions have engaged in some level of debt forgiveness that haven't been publicised. I think there was 1 or 2 cases that were publicised in recent months, but it has happened. It's not clear to what scale it's happened, because quite clearly the financial institutions, taking Deputy Donnelly's approach, have their own interest in trying to ensure that they don't encourage people who can pay not to pay in the hope they make a capital write-off. And the state can't afford that happens either. And so quite clearly there's been public comment made which indicates that certainly if there is to be capital write-off, it's not going to happen easily. Now, as I say, AIB in recent days have come up front publicly and said, we recognise there's a need to do this. There's a need to do it for the health of AIB as well, to get this bank out of under the yoke of uncertainty with regard to the true value of the mortgages that they hold. Now, what about Bank of Ireland? What about Mr. Ray McSharry? I didn't hear what Mr. Ray McSharry had to say. But I would be of the view that if anyone who's a public interest director on a financial institution is publicly or indeed privately stating that their institution will not constructively engage with this legislation, that if they are saying that in no circumstances will anyone be afforded the possibility of a capital write-off, regardless of the financial difficulties in which they're in, that individual is not acting in the public interest, never mind in the private interest of the debtor. And it is an untenable position to publicly state, in the circumstances of this Oireachtas coming together on a united fashion to enact a piece of insolvency legislation which is intent on trying to assist people in debt difficulties in a constructive way, whilst at the same time facilitating creditors to recoup at least a portion of what's due to them in a manner that doesn't involve the expense and complexity of bankruptcy proceedings. Now, I would hope that Deputy Donnelly, and I absolutely know he wouldn't do this deliberately, so I don't want him to take offence. I hope he's either misreporting in some sense what Ray McSharry had to say, or that perhaps what Mr McSharry said wasn't adequately thought out in the context of the insolvency legislation going through the House this evening, or perhaps we need to remember that this is a position that those involved on the boards of financial institutions or who are engaged in the position of chief executive is the position that they've taken up pending the enactment of the legislation. And when the legislation is enacted, they're going to have to review their position. But there be no doubt about it, whether it's Bank of Ireland, whether it's Mr Boucher, whether it's Mr Ray McSharry, they must ensure their institutions constructively engage under this legislation in the public interest, in the interests of those who are caught in financial difficulties, and in the interests of their own institutions and their credibility. Because without putting a tooth in it, we all know, and it's no secret, we all know that the level of indebtedness that people incurred, the property bubble that was experienced, the property collapse that was experienced, was dramatically and substantially contributed to by the financial institutions of this state. They failed to undertake appropriate due diligence on individuals' capacity to repay loans that they acquired. They failed to have any regard to the sustainability of the increase in property values, and they threw money like confetti at developers to purchase land at inflated prices, and contributed in an enormous degree to the property bubble and to the difficulties that many young people are now in. Too many young people who thought they were being responsible purchased homes at inflated prices for fear that if they didn't purchase when they did, they would never be able to own a home in this state. And banks helped to fuel that. Banks helped to fuel that. Now, none of that solves where we are today. But I'm going to be very clear about one thing that I keep on saying. If I find, within a short time of the operation of this legislation, that all or some of the financial institutions are intent on not engaging constructively with the personal insolvency arrangement provisions, for whatever reason, I will not be slow to bring proposals to government to amend the legislation. Let there be absolutely no doubt about that, of any description. And again, I want to thank Deputy Donnelly for raising the issue. We do have to be careful with this legislation. I keep on saying this, that I'm very, very conscious of its importance to people with family homes and negative equity who are in enormous financial difficulty. But it's insolvency legislation that goes beyond just those circumstances. It applies to the broad gamut of circumstances in which individuals can get into financial trouble, and it doesn't all relate to family homes. And the great benefit of the personal insolvency arrangement is that for people in financial difficulty, it affords to them not just the possibility over a period of years of working out of those financial difficulties, but the possibility of retaining ownership and occupation of their family homes, which is something that won't occur when, if they have to resort to bankruptcy. So all I can say to the Deputy is this, in conclusion. I'm very disappointed to learn of comments that have been made in a committee of this House today. I would hope that the individual who made those comments will reflect on those comments. I would expect, once the legislation is enacted, that there will be the fullest cooperation from financial institutions in working carefully, sensibly, and with intelligence the legislation. But if there are difficulties, I will not be slow to amend the legislation. And it's very important that that is understood outside this House. Now, I would have to say that the government has engaged with the financial institutions in the lead-in to the enactment of this legislation. I myself met some weeks ago, because I thought it was a useful exercise to do so, with both AIB and with Bank of Ireland. And what I'm now saying in this House, I said very clearly at that meeting. One of the attendants of that meeting was Mr. Boucher. I would expect he understands exactly where government is coming from and what our concerns are and what Bank of Ireland should do in the context of operating constructively and sensibly the legislation, engaging with personal solvency practitioners, engaging with the circumstances of their own customers, and ensuring that appropriate and sensible arrangements are made. Deputy Donnelly is right, of course. The bank, and indeed it applies to AIB as much as others, they do have a duty to try and recoup debt owing to them. They also have an obligation to recognise the debt that is not recoverable, and not to maintain a pretense that some part of a debt that can't be recovered is actually recoverable, and to recognise where those debts exist. This legislation provides the mechanism for that, and I hope we don't find ourselves back here too soon having to amend it. But I've no doubt all of us, both in government and on the opposition side of this House, will be watching very carefully how the legislation works in the early months of its operation.
Deputy Donnelly, are you?
Thank you, Minister. As before, I appreciate your reply and I appreciate your intent. I would encourage you to take a look at the video of the interactions both with Deputy Pearse Doherty and myself. If you want to, you obviously have to draw your own conclusions, and I appreciate you haven't seen what he said, but I can give you quotes which are: no debt forgiveness, none. There will be no debt forgiveness. We will not be writing off any debt. We're not going to do that. And in my questioning, I pointed to the monitor where this conversation was going on. I said, in the context of the legislation we passed tonight, and his view was, we'll deal with the legislation, but there will be no debt forgiveness. To my mind, Richie Boucher basically said the same thing in the public domain yesterday. Certainly if the reports are accurate, what I read. And indeed, Mr. Masding, when he came before the Finance Committee just a few months previously, said exactly the same thing. So this is publicly stated policy by Richie Boucher. It is publicly stated policy by Mr. Masding. It is publicly stated policy by Mr. McSherry, and I agree with your interpretation. I was shocked by what I heard, and I think various members of the committee were shocked by what they heard. I also fully accept your statement that you will bring this back and tighten up the legislation if it's needed, but my concern is this. It could take at least a year before there is sufficient space and momentum and evidence to bring this back. It could then take you and your officials another length of time, obviously, to reconstruct or amend very complex legislation. Now, there may be a cabinet reshuffle before that happens. There may be a general election before that happens. Now, I hope you stay as Justice Minister, but we don't know that. So it could be a year and a half before there is sufficient evidence gathered, and there is space within the Oireachtas, and there is time for you, your officials in the AG's office, to construct the amending legislation. You may not be Justice Minister at that stage, and that concerns me. There may be a new government at that stage. That concerns me. And were I the banks, that's exactly the game I would be playing. And that seems to be exactly the game that they are playing. Specific to the amendment is about 3 years versus 8 years. I agree that it is a 3-year period, and I'm not suggesting it's an 8-year period. We all know that because we've been living and breathing this for quite some time, and obviously you and your officials more than us in opposition. But at the negotiating table, they won't know that. The bank may know that, but the distressed borrower who you meet, who we all meet, who walk in on their own to these banks and are met with lawyers and are met with accountants and are met with anonymous bank officials, the distressed borrower won't know that. And the real power of this legislation, Minister, as you know, is not how it's interpreted by the courts, hopefully. It's how it plays out at the negotiating table. It's what never gets seen. It's in the deals that get done. And the bedrock for this legislation was a credible threat of bankruptcy. I was willing to accept the bank veto, and I believe the banks will use their veto. They're publicly stating they'll use their veto, maybe not AIB, but Bank of Ireland and Permanent TSB are. Because ultimately that was superseded by the credible threat of bankruptcy. If not technically, in real terms at the negotiating table, Amendment 200, I believe, removes that credible threat. Because were I acting as the bank, I'd look through this and I'd point to the 5 years, and I would further point to the line that says, any order under subsection 1 or varied under subsection 5 shall cease to have effect on the 8th anniversary of the date on which the bankruptcy was the bankrupt was adjudicated bankrupt. The 8th anniversary. I would show that to the man or woman who came in, who hasn't been sleeping for months, who is in unbelievable stress and who doesn't have access to lawyers and accountants and so forth. I'd show them that line and say, look, on the 8th anniversary, that's when you're going to be free. So you'll be bankrupt for 3 years. And if after the 3 years you manage to walk away from the negative equity, the distressed mortgage, if you then try and get on with your life and work hard and earn money and invest in your future and invest in your children's future, I'm going to take all of that off you for the next 5 years. And it doesn't matter that technically there are all sorts of hoops that have to be gone through, and the official assignee may or may not give it to them, and we don't know what percentage of the income they will give them. At the negotiating table, that doesn't matter. What matters is 8th anniversary, and that's what they're going to use. So if we go back to our example of the borrower, 400, they could service 250. How this is meant to work is that 150 is surrendered. But Richie Boucher and Mr. Masding and Ray McSharry are stating publicly that that's not what they're going to do. They're going to use their veto. They're going to say, we're not writing this down. What we're going to do is we're going to take the amount off you that services the 250. We're going to park the 150. But we're never going to let you off that. And we are using our veto, and we don't care that you've got this personal insolvency professional. Because we don't have to engage with this legislation. We have a veto. And the only credible threat you have is a voluntary surrender coupled with bankruptcy, and that's 8 years. And therefore, you're going to service the 250, and we are never letting you off the 150. So I accept what you're saying technically within the legislation. And I believe our intent for this legislation is the same. We differ on how it is going to play out. And as I said before, Amendment 200, I believe, removes the single most important part of this legislation, which is the unambiguous, bounded 3-year period. Thank you.
Are you pressing the matter to a vote?
I am, yes.
Deputy McLaughlin.
I'll be very brief because I talked at great length a little while ago. There's only just one issue that Deputy Donnelly is missing. The debtor won't, in those circumstances, be walking into the bank, faced by the bank's lawyers and the bank manager pointing out the section, because there'll be the personal insolvency practitioner who will be the expert, who will be the intermediary, who will be able to deal with, and talking to the creditors, any threats that might be made and put them in context. Now, I just want to point that out because I think it's an important issue, because we all know that people are intimidated by their bank manager, by their banks, and they're fearful, and they feel very dependent, and they're very concerned, and on occasion so stressed, they're not able to engage in a way that perhaps of assistance themselves. This is the importance of the personal insolvency practitioner, an individual who sits down with the debtor, goes through income, assets, liabilities, resources, what's there, and engages with the creditors and then puts together a plan. Now, if the financial institution, whichever one it is, isn't cooperative, well, it may not be possible to conclude a personal solvency arrangement. But if there is a level of cooperation, if it's what I describe as snarling cooperation, over embedded with threats, it's going to become very apparent at a very early stage in this process that that's the way financial institutions are dealing with this. And if I could say to the Deputy, this government is a lot more resilient than I think he might be suggesting. I don't think we're going to have a general election in the next 1 to 2 years. I can't predict how long I'll be in this post. No minister should ever predict how long they'll be in any post. But I'm articulating government policy, not just my personal preference. It is government policy that the financial institutions engage constructively, and that there has to be, in appropriate circumstances, genuine engagement which may involve debt forgiveness. Now, if we find in the early days of this legislation operating that either no financial institution is willing to engage in that manner, or there's only 1 or 2 that do and no one else will, well, I'll tell the Deputy it won't take me 1.5 years to come in here with an amending piece of legislation. It ain't going to happen that way. So I just want to say that because I think it's important. But we do have to get experience of how this works for some months at least, and we have to see what place creditors are in, including secured creditors, after the legislation is enacted. And again, in the context of the reports he gives of comments made this afternoon in a committee of this House by one individual, I would find, as I said, such comments extremely disappointing, not reflective of the public interest. And it's important, perhaps, that that individual give greater consideration to the proper workings of this legislation, because if there's a lack of cooperation, we have a remedy in this House to deal with that.
Deputy McLaughlin, yeah.
Thank you. I commend Deputy Donnelly for raising this matter, and in fairness, he's raised it right throughout the process. I mean, you know the themes of concern, that we wouldn't have a situation where, you know, the bankruptcy period would be reduced in real effect, and that this was one of the areas of concern that were there. There's also the concern around the issue of a bank veto. As you know, there are amendments put in by all groups in the opposition here to try to curtail that too, and that has been resisted. But Minister, I've had a chance to read over some of the comments made by Ray McSharry and indeed his colleague Margaret Hayes. 2 of them there are the public interest directors of Permanent DSP. Just for the record, they've been paid €510,000 in fees since 2008. It's a hell of a lot of money to represent the public interest, and I'm absolutely shocked at what Deputy Donnelly has reported and what I've just read myself here, being picked up about these comments. It's just absolutely against all of the debate that we've had in terms of debt forgiveness in Irish society over the last number of years, and I think that's the government have had an objective to deal with this issue, but obviously Deputy Donnelly has spoke at length about this huge area of concern that people in real effect may see themselves not having a reduction in the period of bankruptcy. It's a very punishing system that we have in terms of bankruptcy in the state. But I have to say, Minister, and I know you've sort of commenced it, but it's going to be critical that, you know, I presume this bill will be passed tonight. It will go to the President for his stamp of approval. But we then need to reassure the public that at last there is some mechanism in place, some process in place that allows people out of, you know, who were not reckless, who believed what they read in the papers or heard on the TV or radio from their political leaders, economists, those who are professionally qualified, estate agents and so on and so forth, that that there would be a soft landing if anything went wrong, to get out there now and purchase a home and invest. We know of 24% of our people are in mortgage distress as we speak. Absolutely huge. I think it's about 180,000 families and individuals in mortgage distress. So we have a real crisis on our hands, and this is part of the response to that. But it's critical that the message come from government that if the banks and the financial institutions abuse any element of this legislation to prevent genuine debt forgiveness to genuine families who are in that situation, that this government will immediately, as quick as they pushed through the family home tax last night with a guillotine, immediately move to address that issue. We have serious concerns. Deputy Donnelly has outlined his concerns, but we genuinely hope that the impact of this legislation is to make a difference. But if the very arrogant comments of Mr. Ray McSharry or Richie Boucher or anybody else that are acting against the public interest, by the way, I don't need to remind you, Minister, these financial institutions are under the control now of the Irish people. There needs to be a little bit of humility particularly amongst public interest directors. My final point is this, and it just throws the whole thing into sharp realisation tonight. The Law Reform Commission held an event there last week where one of the main focuses was corporate responsibility and legislation in that whole area, and white-collar crime and so on. Some really, really interesting contributions. But one of the questions at the end was just to clarify from very eminent experts who were there, as you'd expect at the Law Reform Commission, indeed international experts from this country, asked about what is the role of the public interest directors to define what is it they have achieved. And it was quite clear from the responses that they weren't quite sure. But ultimately, they appear to be still acting in the interest of the bank and the shareholders, even though that's not what they're paid to do. So, Minister, I do appreciate your immediate response to these comments, and obviously you haven't had a chance to look at the transcript, but I would also invite you, as Deputy Donnelly has done, to have a look at these comments, to immediately move after this legislation. I presume, obviously, you have the numbers, you'll pass it. When it's passed, to immediately move to reassure the public that those comments, which it's outrageous that they're made, particularly today, that those comments are immediately rebuked, immediately confronted, and that a reassurance is given that if the banks seek to abuse this legislation and to seek not to meet their responsibilities to give people who are genuine a chance for debt resolution, that your government will move extremely swiftly, as you have, as say, with the property tax, family home tax last night, to immediately address whatever arises and to put this thing straight. This is if it's not the biggest challenge, it's certainly one of the biggest challenges that faces our people over the next generation, is the issue of mortgage distress, debt resolution for families, and that chance to move on, and debt forgiveness. And I appreciate, Minister, there's a huge amount of work in this legislation, massive amount of work, massive amount of deliberations. Myself and Deputy Collins particularly have sat through all of that with you, and we want to get to a point, we want to work with that. We have serious concerns. If those concerns prove to be vindicated very, very quickly, then I would urge you, Minister, to see to that offer that you move extremely quickly to reassure the public. We can't have this legislation, all the work that's gone into it, all the goodwill that's gone into making this come about, be torn apart by people who are acting against the interests of the Irish people and who are paid, unbelievably paid by Irish people. Thank you.
Deputy Boyd-Burris.
Yeah, just on behalf of the United Left Alliance, I'd just like to add our concern and disappointment, really, that while in general terms, I think we all want to achieve some relief for those that are in mortgage distress or are stuck under the burden of significant personal indebtedness, and I think there is a genuine desire across the House to do something about that. It is disappointing to us that we have not gone in this legislation a hell of a lot further. In the amendments we proposed at committee stage, pretty much all of which were ruled out of order, we urged that a model where the insolvency agency that the government is going to be establishing would actually have the power to impose fair settlements on the banks. It is disappointing that the government hasn't taken that road, as is the case in some other countries. The particular model that we looked at was in Norway. Indeed, it seems to me that in Norway they have lots of models that we could follow on a whole range of levels when it comes to managing the relationship between the state and private interests. But that there would be much stronger imperatives, legal imperatives, completely safeguarding the family home, and a body that could, an independent body, if you like, that could impose a fair settlement and write down where needs be on the financial institutions, on the banks. And I think that's what we should have done, what we could have done. And frankly, I think it is the only thing that is going to resolve this big problem. I mean, at any stage, this sort of legislation would be important to update and improve our legislation. But we're not just at any stage. We're at a stage where the entire economy is suffocated with this stuff, and where there's a very serious question mark over whether it is possible to talk about anything approaching economic recovery if we do not deal comprehensively with this problem. And I think the concern that we feel and other deputies have expressed is that we're not going to do it with this legislation because it doesn't go far enough, and it still leaves the whip hand with the banks. And that is disappointing, particularly because I was at the Finance Committee, the Deputy Donnelly referred to, and I heard the Minister's response to say that he is disappointed that an individual should display that attitude. But it's absolutely clear it's not an individual. I mean, the CEO of AIB was slightly more polite in the way he put it, but actually he said more or less the same thing. And the CEO, Mr. Boucher of Bank of Ireland, wasn't terribly polite, but really he was doing what is logical from the point of view of a commercial entity, which is a bank. If you're operating a bank on the sort of commercial basis that they see themselves operating it on, then what they're doing is logical. It's not really of great interest to them whether people are in distress or whether the economy is banjaxed because they don't give significant debt relief. That's not their concern. Their concern is to maximize profits, to restore their balance sheet. That's what they do. Now the question is, are we going to intervene with legislation and other powers to adjust their priorities so that their priorities do align themselves with the public interest to a greater extent, with the interest of distressed mortgage holders and with the economy and the public interest as a whole? And it is very clear that in our conversations with them, they just don't get that. They actually think that their interests are the public interest. That was what emerged from the discussions. They think what's good for them is good for us. But it's clearly apparent that what's good for them isn't good for us. And this message needs to be hammered into their head in some way. And I mean, on the issue of public interest directors, one thing that emerges from it is we have to tell the public interest directors what to do. We have to hold them to account. We have to instruct them how to represent the public interest on the boards of banks and to actually go in batting for the public interest on issues like mortgage distress. But in this legislation, what really you're saying, Minister, as I understand it, you're saying, well, the threat of bankruptcy, if they don't do a reasonable deal, will be enough to push them to do a reasonable deal. But as Deputy Donnelly has outlined, there's a very serious question mark when you have this 8-year, rather than 3 years where you can walk away. So we would like it to be stronger. Obviously, we recognise that even with all its limitations and shortcomings as we might see them, this still represents an improvement on the status quo, where people have nothing, or a complete limbo. So I don't think certainly it's not a case of voting against the legislation. But I can tell you at this stage, we think the legislation is inadequate and is not going to do the job. And we have to register that fact with you in some way. And the logical way for us to do that is to vote against this particular amendment that qualifies the threat of bankruptcy, which a debtor can use to try and put pressure on the bank, but which this very seriously dilutes.
Deputy. Deputy Donnelly, how stands the amendment? You're pressing it, yeah. Minister, you're not accepting the amendment? Okay. I'll put the question then.
I've proposed the amendment. It's our amendment. So I think you're voting against our amendment. So I think
Yes.
we all get completely confused at the end of this.
Okay.
Yeah.
That Shannon agreement 200, that Shannon amendment 200 be agreed to. Those in favour say Neil. I think the question is carried. Vote all, okay.
Thank you. Item number 2, Personal Solvency Bill 2012, amendment from the Shannon. Amendment number 200. The question is that the Shannon amendment be agreed to, and on that question, a division has been challenged. Tellers Deputies Paul Keogh and Emmett Stagg. Tellers Neil, Deputies Padraig McLaughlin and Stephen Donnelly. Thaw 87, Neil 44. The amendment is agreed to. Amendment 201 already discussed with 107. Is the amendment agreed to? Agreed. Amendment 202 to 212 inclusive are related and will be discussed together. Is 202 agreed to? Agreed. Amendment number 203 already discussed with 202. Is that agreed to? Agreed. 204. Sorry, could I have a bit of 204 already discussed with 202 that the Shannon amendment be agreed to. Is that agreed? 205 already discussed with 202. Is the Shannon amendment agreed to? Agreed. 206 already discussed with 202. Is the Shannon amendment agreed to? Agreed. 207 already discussed with 202. The Shannon amendment agreed to? Agreed. Shannon amendment 208 already discussed with 202. The Shannon amendment be agreed to. Is that agreed? 209 already discussed with 202. Shannon amendment agreed to. Shannon amendment 210 already discussed with 202. Is that agreed to? Agreed. Shannon amendment 211 already discussed with 202. Is that agreed to? Agreed. 212 already discussed with 202. The Shannon amendment agreed to? Agreed. Shannon Amendment 213 to 218 inclusive are related and will be discussed together. Is Amendment 213 already agreed to? Minister, Shannon Amendment 213.
Yes, this is dealing with the new Part 5, Ceann Comhairle, in relation to the bill. The new Part 5 makes provision for the regulation, supervision and discipline of personal insolvency practitioners. The Insolvency Service will be responsible for the direct regulation of personal insolvency practitioners. We will not be imposing any particular restrictions as to the type of professions of persons who will be licensed to perform this function. Normally, looking at the experience in other countries and other jurisdictions, such insolvency practitioners tend to be accountants or lawyers, but can also be other professionals in the broad financial services sector. Indeed, individuals trained as mediators with financial experience may well prove to be very effective personal insolvency practitioners. In the context of existing professionals, many of these will already be regulated as appropriate by the central bank, where they are financial intermediaries, for the provision of other financial services. That is the approach I intend to take. Suitable persons meeting the normal fitness to practice and competence criteria, having indemnity insurance, which is important, and who meet the other requirements of the legislation will be able to apply for registration on an individual, not on a corporate basis. I now want to turn to the detail of the new Part 5. Amendment number 202 proposes the insertion of Section 147, which provides for the interpretation of certain items used in the new Part 5. Amendment number 203 proposes the insertion of Section 148. This new section provides that it will be an offence for a person to act as a personal insolvency practitioner who is not entitled to do so by virtue of this legislation. Amendment 204 proposes the insertion of Section 149. This section gives the Insolvency Service the power to make regulations to provide for matters such as procedures governing the authorisation of persons to carry on practice as personal insolvency practitioners, the standards to be observed by personal insolvency practitioners, qualifications and requirements as to competence, information to be provided to the Insolvency Service by personal insolvency practitioners, and the circumstances and purpose for which a personal insolvency practitioner may charge fees or costs.
213.
Oh, I thought we... I didn't think we'd reached 202 yet.
No, we...
Well, we must have done it without. You must have just nodded it through for me. I was anxious to put on the Dail record the background provisions, but I'm very happy, if need be, to go straight on to 213. But I would have thought it was appropriate that but you're happy then without dealing with that. Well, Chapter 2, in relation to Amendment 213 to Amendments 218. Chapter 2, comprising sections 158 to 160, sets out a number of general obligations that apply to personal insolvency practitioners, to whom I was referring a moment ago. Amendment 213 proposes the insertion of Section 158. This section imposes an obligation on personal insolvency practitioners, or PIPs for short, and I think I'll refer to them as PIPs from now on, to keep records of their activities in relation to debtors for a period of not less than 6 years after the completion of the activity to which the record relates. Amendment 214 proposed the insertion of Section 159. Under this section, a PIP will be required to have a policy of professional indemnity insurance, as I previously referred to, which meets requirements that may be prescribed in regulations. Amendment 215 proposed the insertion of Section 160 to provide that a PIP will not be permitted to charge fees or costs which are not incurred, either in accordance with regulations made under Section 149, under Section 149, or in accordance with the terms of a debt settlement arrangement or a personal insolvency arrangement. Chapter 3, comprising sections 161 to 163, contains important provisions dealing with accounts and related matters. Amendment 216 proposes the insertion of Section 161. This section empowers the Insolvency Service to make regulations regarding financial matters, including the rights, duties and responsibilities of a PIP in respect of monies received from debtors, the accounting records which must be maintained by a PIP, and verification and enforcement of compliance with the regulations. Amendment 217 proposed the insertion of section 162 to provide that the Insolvency Service may, where necessary, apply to the High Court for certain orders in relation to banking accounts kept by the PIP in his or her capacity as such, or in relation to the assets of the PIP. Amendment 218 proposed the insertion of section 163, which aims to address situations where a PIP is no longer authorised to carry on practice as a PIP and the person has not made adequate arrangements for handing over documents relating to his or her practice to another personal insolvency practitioner. In such case, the Insolvency Service may issue a notice requiring the production of documents to the service. When the person does not comply with such a requirement, the service may apply for a circuit court order requiring the person to comply with the requirement.
Is Amendment 213 agreed to? Agreed. Amendment 214 already discussed with 213. Is that agreed to? Agreed. Amendment 215 already discussed with 213. Is that agreed to? Agreed. 216 already discussed with 213. Is that agreed to? 217 already agreed with 213. Is that agreed to? 218 already discussed with 213. Is that agreed to? 219 to 229 inclusive. 243 and 244 are related and will be discussed together.
Count Chapter 4, comprising sections 164 to 174, provides for a comprehensive system of complaints and investigations where improper conduct by a PIP is alleged, and for the imposition of appropriate sanctions. Amendment 219 proposed the insertion of section 164. This empowers the Director of the Insolvency Service to appoint members of the staff of the Insolvency Service or other appropriate persons to act as inspectors for the purpose of the bill. Amendment 220 proposed the insertion of section 165. This section provides for the establishment of a panel of persons to act on the Personal Insolvency Practitioners Complaints Committee. When the service appoints an inspector to carry out an investigation into a PIP's conduct, must request the Minister to appoint a complaints committee from the panel to act in relation to the investigation. Amendment 221 proposes the insertion of section 166. This section provides for the making of written complaints to the Insolvency Service alleging improper conduct by a PIP. It sets out the procedure for the handling of such complaints by the Insolvency Service. Number 222 proposes the insertion of section 167. The section provides where the Insolvency Service considers that immediate suspension of an authorisation to carry on practice as a PIP is necessary, may make an application to the High Court for an order to suspend the PIP's authorisation. In exceptional circumstances where there is an immediate risk of financial harm, the Insolvency Service may apply to the High Court on an ex parte basis for an interim suspension of a PIP's authorisation for a maximum of 14 days. Amendment 223 proposed the insertion of section 168, which provides that an investigation may be carried out by the Insolvency Service on foot of a complaint or on the service's own